Justice.
You've been in practice for a very long time. Just tell us briefly why you believe you are the one to be recommended for appointment.
Well, Chief Justice, you've said for a very long time. I'm not so sure it's been a very long time, but it's been some time that I've been in the field of law. And I think at this stage, I ought to have acquired some form of experience which I can share with my country, not only finding my services to the Pretoria, although I do go to other divisions. But if I'm a judge, then I'm able to contribute not only by confining myself to the division where I'm appointed, but if you write judgments, then you subject yourself to criticism by the juries, by the lecturers at the universities and so on. So in that manner, you can contribute towards the development of the law.
By the way, for how many years have you been senior counsel?
This is my 11th year.
Yes. And you've acted as a judge severally?
Since 2003.
Yes. Very well. Commissioner Malema?
Thank you very much. I'm sorry to ask this question. How old are you now?
I'm 64, Commissioner Malema.
And now...
You don't have to be sorry.
If you are in a position of appointing 2 people out of 3, very good people, black African female, a 44-year-old African male, and a 64 years old into the bench, all qualified, well experienced, what will you do?
Well, it's not for me to say. It's for the JSU to decide. If they want to appoint the younger one, it's much better. If she's acquired equally the same experience as the old one, it's all right. I don't have a problem with that, even with myself. But statutorily, I still have 10 years to render my services as a judge. So there's more time.
We're not talking about the same subject. I'm talking about something else, and you're talking about the JC. I'm talking about you, and you cannot be a JC. You are in a position where you must choose 2 people, and I've given you this scenario. What options will you take in the interest of empowering the young ones to ensure that we build and continue to grow potential young judges, and in the situation where we are also thriving for gender empowerment, and given the fact that we also have a 64-year-old, 64, 44, and a female, what will you do in that scenario?
I wouldn't know if I would ever be in that situation, but it all depends on what you want. I would imagine that the age would not be the only criteria you can measure your decision. And you would have some other aspects to take into account, but it really depends on you. But empowerment of women, and so is what I also encourage young people. In fact, maybe that's why I stayed longer in the as a silk. That was my aim as a silk, was to empower my people. For that matter, I have now, as I speak, there are 3 senior counsel, one of whom is the 4th one is a white. So I've empowered a lot of young people in the field as advocates. The male ones are countless. Senior, some of them are judges for that matter. So I wouldn't really have an objection if let's take my case now. If you have a young female who is well experienced like myself, and you feel that she should take the position, I don't have a problem with that.
Well, the age difference ordinarily will suggest that they will never be experienced like yourself, because you had an advantage of age and they are much more younger than you. But when it comes to testing them, they are on the understanding of the law and all the requirements. All the three of you are superb. It's what we are looking for. The only thing we are left with now is gender and age. It will be ideal for the judiciary to actually get a much more younger person if it had to choose between the two, because it makes more sense that they will stay longer, they will continue to serve, and that will be like an investment, actually, as it were, in the judiciary.
Well, that's fine. One of my experiences is that actually judges don't retire. You still have judges who are way beyond 75 years. They're still working in the service in the sense that they are appointed in commissions, they are appointed in various capacities. And so a judge doesn't really retire as such. You remain a judge until you die. So you remain, in my view, to be committed to that profession, if I can call it that, of a judge.
What is your take on Muti?
Muti?
Yeah? Muti, the African herb.
Well, whether you believe or not, there is a talk of Muti. I personally don't have any thing to express on that, my view on that.
So you think people can take Muti and get engaged in different activities because they are motivated by Muti?
Yeah, I don't believe in Muti, and for your information, I don't believe in it.
And you don't think that people can be motivated in whatever way possible by Muti? They can get Muti and as a result of Muti engage in an activity because they are motivated by Muti.
My experience, both as a magistrate and as a, they put it as an adult African, I know that blacks, certain sectors of the black people believe in Muti. And my view is that whatever you believe in, it works for you. Some people believe in church, in a certain categories of churches, and those churches, they advance their interests and so on, so things work for them. Some people believe in Muti, and in their view, they have faith in that, and it works for them. So it all depends on your belief. Personally, I don't believe in Muti. I don't get involved in that.
But people...
I cannot deny that the black people, there are certain categories of people in black communities who believe in Muti. And I don't condemn them for doing that. I don't share any views to say they're wrong in that. It's like church, as I say.
But do you think a group of people can act because they are motivated by Muti? Get into action because they are influenced by Muti?
Well, I wouldn't venture to know what the group, because you know what, in my experience is that people act differently. When you act when you have an individual mind, you've got that mind. You exercise your discretion in accordance with what you believe in. But a group mind, you must act as a group, and you've got a group mind. Psychologists will tell you how those people behave. I'm not a psychologist, so I can't be in a position to say if these people have this belief, then they must behave in this way. I'm not a psychologist. I'm sorry to say that.
I think maybe if I may, do you believe, this is what I think Commissioner Malema is getting to. Do you know it to be the position or not that some African people believe that there is power in Muti which could either protect them or allow them to do certain things? Is it a practice that you can relate to as an African person with your experience? That's part of the question. It may not be the whole question, but as a matter of practice, do you know it to be the case that an African person can apply Muti, confident, for instance, that the bullet won't enter? We had a candidate one day at the JSC saying the Muti, he knows that you can apply a certain Muti, even if they fire at you, the bullet won't enter. He was applying for a labor court position. So can you relate to that?
No, I'm sorry, CJ, I can't relate to that. But I know in the Marikana Commission, there was that, if that is aimed at directing at that, there was that allegation that people have believed that they would be protected, they had used the Muti and so on. We have had that evidence.
And you signed a report that blamed that workers acted because they were motivated by Muti.
Is there a clause where we said in that report that those workers were motivated by Muti?
Yes.
I don't remember it.
So you signed things that you don't remember?
No, I don't remember. We never said, as far as I'm concerned, we didn't say that those people did what they did because they were motivated by Muti. That report, there were a lot of allegations in that regard. Fortunately, the three of us didn't believe in Muti. That is Judge Tokota and then Advocate Emrach Hesse, but the allegation was there.
Now, can you explain the judgment where you recently gave a judgment and absolved a white person who had put a black guy in a container?
You know, the way I was trained, right from the start, when I came from the university, I never prosecuted. I missed that opportunity to prosecute. I was a magistrate immediately, right from the university. My train of mind is that you don't look at who is this. Is it a white person? Is it a black or whatever? You look at the facts and you interpret the law in accordance with what you believe is the correct position, regardless of whether it's a white or black. You don't look at the colors. Otherwise, a judicial officer who does that, then it can pose a danger to certain societies, because then you have also to preside over certain cases which may involve certain religious beliefs, and if you don't believe in this one, then you have to give judgment in favor of this one which you believe. You've just got to, all what you have to do as a judge is the ability to identify the issues from the facts given to you in civil trial matters, even including criminal matters for that matter. It's very difficult to evaluate evidence and come to the accurate decision. But you try your best with your experience to evaluate facts, and then once you have identified the issues, then you apply the law. You don't look at who is this, who represents who that, who is the plaintiff, who is the defendant. That you don't consider as a judicial officer. That's my view as a judicial officer anyway.
No, that's not the question. I want you to explain that issue where a white guy, you put a black guy in a container and there was nothing wrong. In your view, I hear what you are saying.
The issue was defamation in that case. We're not talking about putting a guy in the container and then find a judgment in that regard. No, that was not the issue. The issue was defamation by the newspaper, by the way, not the guy put in the container. That was the issue.
Now, as a judicial officer, it's always important to look at the law, but it is equally important to look at the people who appear before you may come from a very strong background. For instance, males can always dominate females, and whites can always have got a history of having dominated blacks. And to want to ignore all that this one comes from a position of authority, can be misleading at times.
I'm not too sure. You know, in my view, there are 10 commandments of a judicial officer. One of which is impartiality. One of which is independence. One of which is patience. One of which is prompt. There are 10 of them, which I have. I don't want to waste the time of this house. I'm sorry about that. So you don't look at who is bringing this, you look at the facts. Like I said, I'm not going to change that. You don't look at the background. That's something which you can apply, and maybe when you look at the, you'll excuse my language. Maybe when it comes to, say, mitigation of sentence, you may look at the background. He stole bread. The background is such, they don't have food. They're living in shacks and so on. So I don't have, he has committed an offense, but I don't have to send him to jail. Those are the factors you can look at, the background. Only when you're dealing with situations like that. When we talk civil matters, like the one you've just referred to, you don't look at that. You don't look at, what's your background? Where do you come from? Okay, if you come from a disadvantage, then I must give judgment in your favor. That's not how you apply the law. That's not how I understand the application of the law anyway.
But you just agreed that it is important to look at background, because without taking into consideration the background of where we come from, you might give a judgment which perpetuates the inequalities that we have been subjected to as a country. And therefore, it is permissible in law to look at the background. You just said that yourself.
Yes, I've told you under what circumstances, not in all the cases. I'm told you under what circumstances you look at the background. Even the criminal matters, you look at the situation, the nature of the offense committed by the person. You can't say because this man, he has murdered a person. Okay, he comes from a disadvantaged background, I can't sentence him to jail. No, you can't do that. So I'm telling you the circumstances under which you can look at the background.
But it will be
otherwise, let me sorry to cut you. Otherwise, if you look at the background, you look at this, they say it's a criminal. There's a background, the previous convictions have now been handed up. The background of that is that this man has committed criminal offenses. You look at that, you take that into account, but that is after your finding of guilty. You don't look at it whilst before you make a finding on the issues, you see.
But the point I'm making, it is in the context of racism that in taking into consideration where our country comes from, you can't ignore the parties that appear before you, particularly in a matter that can perpetuate racism in this country. I'm not talking about the matter now that you dealt with. We're talking about, as a judicial officer, you can't act ignorant and adjudicate on a matter based only on the facts before you, neglecting the background of where we come from as a country.
That's not how I was trained. No, I act also in these divisions. None of the senior judges trained me in that way, that you must look at the background first before you decide the facts. No, that's not how I was trained. I was a magistrate for 15 years, 4 of which I was training magistrate myself in the whole country. So I never said to them, before you come to a decision in the matter, look at the background, ignore the facts. Look at the background. Oh, that one is a white, he was a racist. Okay, let me come to the facts. You were a racist, therefore, I'm giving judgment against you. That you don't do as a That kind of
Which
not permissible in law anyway. There's the head of the judiciary. He will agree with me that it's not permissible in law.
you're a magistrate 15 years, which years?
Since for that matter, since since 1979, I had not yet even qualified. In 1979, I had come back after the Steve Biko incident had an effect on me, so I didn't pass my law degree. So in 1979, I had to come back and work, but I was immediately appointed as an acting magistrate for the whole year. And then from 1980, I'm sorry, 1978, it was in 1978, I'm sorry about that. 1979, I went to the university again. And then from 1980, that's when I started permanently on the bench.
And then who trained you? Because you've got this pride, 15 years of being a magistrate. Who trained you?
The judicial officers. I don't want you to drive me to racism. I'm sorry, please.
Oh, but you are trained by apartheid mechanism, trained institutions.
You know what? Let me just tell you a little story. As an advocate now, there was an attorney who was a black attorney who was being. There was an application to strike him off the roll because he has not complied with the legal profession. I had to represent him. The papers were already drawn. The papers were saying this court is an apartheid regime court. The judges are apartheid, are racist. I'm not supposed to be subjected to them. The first thing that the judge asked me, I said to him, how do you draft papers like this? And then he said, no, Tokota, I want you to represent me. Then it's the first thing that the judge asked me, Mr. Tokota, these papers, do you agree with them? I said, no, I don't. I don't agree with that. Apartheid and no apartheid. The law is law. If it was apartheid law, it was law at that stage. And everybody had to go along that law. Not that you liked it. You didn't have, even now, I cannot guarantee that everybody likes the law. You only like the law when it is in your favor. When it's not in your favor, say, ooh, this government. That's what happens in life.
But you're an apartheid magistrate.
Well, call me what you like. I was working at that stage, but I can tell you one thing, I gained the experience.
And you were trained by apartheid government to be a magistrate.
Call it what you like.
And you didn't see anything wrong with that apartheid training.
Let's assume I see something wrong. What should I have done? Should I have said, I'm not going to be a magistrate in this era because you're apartheid. Should I have done that?
I'm asking, you were trained by apartheid regime to be a magistrate. Was there something wrong with that apartheid system?
The law is the law. So it's not for me. I don't make laws. Parliament makes laws. The court, even though those apartheid laws, they were not rigidly enforced by some judges, for example. Some judges didn't agree. That's where you have an opportunity as a judge to develop the law. These days it's even better because there's constitution. Anything which is inconsistent with the constitution, then it's bad law. You don't apply it. So it's no use taking us back to the apartheid. Even the customary law, as long as it is consistent with the Bill of Rights, then you can apply it. It's permissible in law, it's permissible in terms of the Constitution, but if you want to change it, you change it only in accordance with the Bill of Rights.
As you round up, Commissioner Malema.
Was there something wrong with apartheid?
Yes.
What have you done?
What do you expect me to do as a magistrate? To strike and say there's something wrong here?
Thank you, CJ.
Thank you, Commissioner.